What's up, everyone? Thank you for joining. I'm watching in the queue when they're about to go live for the hearing today. Rachel Juarez is going to be about 30 minutes late. She's got a lot going on. She's got a phone call that basically she has to take care of. She said she would be ready to go at about 30 minutes in. So maybe this thing will start late and she'll only miss 10 or 15 minutes. I think they've seemed to start on time in the past. But anyway, thanks again for joining in. Just going to have to listen to me ramble until this thing starts. But, I've been calling it the custody hearing. Technically, it's called the parent review time hearing. So the last one they had was back on June 1st. And I did not cover that live. And I just went to the entertainment sites who recapped the things that were said on that. We did cover it with Rachel Juarez live back 2 hearings ago, which I believe was either April 30th or May 1st, end of April, because then they came back basically a month later on June 1st. And that was the one where she had lost custody of Ever for 2 weeks. And for the 2 weeks leading into the April 30th hearing. And then the judge at that hearing said, okay, we'll give you 12 hours a week. So 3 4-hour sessions is what the judge wanted. Then they came back on June 1st. Oh, by the way, those 3 4-hour blocks were supervised. And then on June 1st, he said, okay, we'll take away the supervision and we'll go to every other weekend and 1 day a week. And that's what it's been since June 1st. But they also added a non-disparagement clause in the last hearing, where the judge said, knock it off on social media, both of you. Do not talk about this case. Do not talk about your child. They can't talk to each other because they currently have restraining orders against each other put in place by the judge to keep them away from each other for at least 3 years and 100 yards away from each other. So all kid drop-offs, I guess, are being handled by DCFS or some intermediate party. And there's been issues with that. Dakota, through his roommate, has been claiming that Taylor is missing some of the time of that with their child. We found out last week that she ended up going to rehab. We thought it was a week. Now it's only 2 days that she went. So there's just a lot. And then obviously I've been talking about it the last 2 days on my podcast, the crash out that she had on Saturday morning on social media, where she was talking about Dakota and Tate, her ex-husband. Now, Tate has nothing to do with this hearing. At least I don't think he does. He shouldn't, because it's all about Ever, and she doesn't have Ever with Tate. She has Indian Ocean with Tate. But maybe what happened with Tate will get brought into this. I don't know. We shall see once this hearing starts. But this is, I'm really, really curious how the judge reacts to what she posted on Saturday. There will be other things, and she's going to come hard. Her legal team will absolutely come hard at Dakota and Crew for posting another video that happened 2 weeks before the arrest in 2023. He posted that on his TikTok, which was Crew basically just telling, or Crew, a video given to him clearly by Dakota, and then Crew even putting in the caption, like, I've got multiple videos that Dakota has sent me. And the reason I have them is because he didn't want to keep them on his phone because he was afraid if Taylor ever found his phone that she would delete them. So I don't know if that is Crew and Dakota indirectly breaking the clause. It seems like it is. Taylor just directly broke the non-disparagement clause because she posted on her TikTok and her Instagram. So I'm really curious. I have no idea how the judge is going to react to this. Maybe it'll be harsh. Maybe it'll be just another, hey, knock it off. But they're looking for more parenting time, clearly. And I don't know if she's going to get it. I guess we'll find out shortly if they're going to increase parenting time, if they're going to decrease it, if they're going to keep it the same. Anything that's not an increase in parenting time isn't a good thing for Taylor, because the last 2 hearings, she has gained parenting time. Going into the first hearing on April 30th, she hadn't seen Ever for 2 weeks. Then the judge said, okay, I'll give you 12 hours a week. And then a month later, they said, okay, I'll give you every other weekend and 1 day during the week. So you would think this hearing, which is a review of parenting time, her side is clearly going to ask for more, probably going to ask for 70-30 again, like they have the first two hearings. And the judge is like, look, I'm not putting you back on the original plan. That's just not happening. You've got to build your way there. But I feel like what she did on Saturday is a step back for her. And then I want to see if Dakota and Crew get in trouble. And the Crew is his roommate. I see if they get in trouble for posting an old video of her and Dakota fighting. So it seems like both would be penalized, but what is the penalty at this point? Is it strong enough to take Ever away from both of them and say, screw it? He's going to a grandparent? Like, I can't imagine that's what we're going to find out today. But I'm telling you, this judge is kind of no nonsense, this Judge Manas, Commissioner Manas. So I'm really interested to see exactly what he does. So I've got my notes. Like I said, if you're just joining, thank you. Rachel Juarez will be joining us around 4:30 Eastern time. So in about 30 minutes, who knows? Her call might last longer. It might go shorter. Who knows? But we will jump in. And right now, they're still on standby. I can pull up the video feed. You can see court proceedings will begin shortly. So we will be watching that. And I'll keep you updated. I'm just watching it to see when they go live. Should be able to hear it. And let me see what's going on my Twitter. Is my Twitter feed actually showing it? Oh, yeah, there's me on my Twitter feed looking at my phone. Hi. Oh, boy, I got a lot to do today after this ends. Still got to record 3 podcasts. I got to watch the stupid Valley. Thank God I'm not recording that with Juliana until tomorrow, but it'll be up right around 3 p.m. Eastern time like it is every Thursday. But yeah, 3 podcasts tonight. Thank you for sending in, anybody of you out there that's sending in emails to be part of episode number 503 coming out tomorrow. I definitely want to talk about what I'm going to implement in regards to Big Brother this season. We're going to have a game that you guys can play along with and win prizes. How about that? For free. So that's good. And what else? There's Luca. Oh, crap. I need to feed them. Oh, yeah. She will bark the whole time. All right. Hopefully. Hey, Judge Manas, can I feed my dogs before you start the proceedings? Thank you. All right. I'll be right back. All right, I'm back, and I'm seeing that the court is in session, so let me pull it up real quick. Put my headphones in. You-
Received a very disconcerting, voluminous document dump yesterday. A lot of it seems to be relative to the motion to set aside the stipulation. Mr. Shattuck, why don't I start with you?
Okay. Well, we certainly agree that the purpose of today is to review parent time, and provided the court a summary that we thought would be helpful. Doesn't address the bulk of the motion to set aside. That's something to be heard by the judge, and we'll get a hearing set on that once
Right.
it's fully briefed. In looking at the custody and parent time.
Hold on. I'm not asking you to go into on the merits yet. We're not there yet. There's also another motion too. It looks like a stipulated motion with respect to consolidate some sort of, well, you characterize it as a Rule 100 motion. It looks like you wanted, everybody wanted to, A, that the case be classified as private, and B, that all the hearing and all of the, or really there's two remaining matters, which are the domestic matters, that they both be heard before Judge Mao and me. There's some issues with that, but I also think that should go to Judge Mao. And the issues, one, are that there was already a stipulated motion to seal the file, and then also there was another motion to keep the media coverage from the file, from the hearings. He had made a ruling on those in one of the protective order cases, and he said no, the parties had not met their overcome the presumption of the open courts provision that we have. So just letting you know that. And then I think there's another issue with the in terms of the Rule 100 aspect, is that it's not the same parties in the rule talks about it when it's the same parties. I think the motion sort of characterized it as close enough, but the case that Commissioner Loon has one of the parties is different than the case that I have before me. I'm just bringing that up, but I think that motion also needs to go to Judge Mao for resolution, because that was brought in this case.
Your Honor, can I speak to the previous motion to seal?
Oh, I'm going to ask that. I'm going to say this too. This is already classified as private. That at least we have open courts. Anyone can attend the hearings, and the pleadings are not available to the public. They're not downloadable, but the orders are public. That's the difference.
Your Honor, a couple
Mr.
comments.
Sminiard, yes. Yeah.
A couple comments on the previous motion to seal. One, it was a different case. It was a protective order case.
It was.
Much narrower in scope. And I do have to point out that it actually was not a stipulated motion to seal.
Okay.
There was some confusion there because we had originally worked on it as a stipulated motion to seal, but then the stipulation fell apart. So my office filed that.
Well, my point was that he made a ruling about it.
Okay.
Right.
I don't have any concerns with the court's direction to have Judge Mao address it. But again, there are some very key differences with it. It's a different form of relief that's being sought. The one that was submitted earlier today is a genuine stipulated motion to seal. And it seemed to me from Judge Mao's comments back in April that part of his concerns stemmed from, well, is this kind of standard evidence and standard issues that are being brought forward? Or are there more sensitive issues, more sensitive materials such as medical records, mental health records? And at that stage of the case, that hadn't played out. Those had not really come out and become a theme in the case, but now they are. And so now the case has gotten a lot more sensitive. When
we met before, when that motion was filed the first time in the protective order case, he indicated, and I think it was in his in a minute entry that he provided, that he would hear it because it could affect the entire case and not just the one hearing at issue at that time. All right. So I'm just certifying that to Judge Mao. And if you get a hearing date from him on the motion to set aside the stipulation, I think you could probably hear these at the same time when you get a hearing date. I know there's a request for a hearing that was put in by way of filing, I just suggest you pick up the phone and call his team and get some proposed dates to initiate that process. They'll email you back with proposed dates. All right.
We will follow up with his team, Your Honor.
All right. All right. So let's get into the parent time issues. I did see some affidavits, some updates for the court, and we have Allison Satterley now in the case. Previously, it had been Mike McDonald, who was from the Office of Guardian Ad Litem, who would be appointed in the protective order matters. Ms. Satterley, as you know, is a private guardian ad litem who's a practitioner and is her first appearance in this matter. I'd like to start with her and see get her perspective on this.
Your Honor, unfortunately, my part will be very brief. Only one side has paid my retainer thus far, Mom's side. I've still not been paid by Dad's side. I've also still not received any of my, I sent out a waiver and an engagement letter form for both parties to sign. Mother has completed those, father has not as of date. So I do insist that I be paid in full before I get involved in a case, especially one where it's a very active case. So I have done very little thus far. I have not met with my client yet. I can't give the court much of an update.
All right. Well, I understand where you're coming from. Any comments from Mr. Shattuck? I think part of the representation was that your client hadn't fulfilled his obligations to get Ms. Satterley on board.
For sure. I got an email from Ms. Satterley, and I recently responded and trying to confirm that she had been paid. She should have been paid some time ago. So this is news to me, but it will certainly explain why she hasn't engaged yet. And so I will make sure that on Dad's side that gets taken care of right away. And I presume the court can allocate that cost hereafter once we determine the parties' incomes.
All right. Okay. All right. Well, who wants to go first on any volunteers on who wants to go first as to your respective clients' positions on what the court, if anything, the court should be doing today?
Yeah. I think, Your Honor, it'd be appropriate for me to start off, and I know I haven't been involved as long as Mr. Swinyard, but long enough to get a feel for how things are going in this case. I think since the last hearing on June 1st, court lifted the supervision requirement, and unsupervised parent time pursuant to 302 was ordered. So let's look at what has transpired, what's happened, what parent time has been taken. So right after that hearing, June 4th, Taylor chose not to take her parent time. We don't know why. We just got a message and she didn't exercise it. On June 5th, she took parent time, but started it 7 or 8 hours late and went through June 7th, that being her weekend. She also took parent time on June 11 and 25 from 10 to 6, even though she's entitled to 8 to 8:30, and then skipped the 18th and also the weekend of 19th through the 21st due to rehab or to the inpatient treatment of whatever sort she received. And then she also took her weekday parent time on June 25th and July 2nd, again from 10 to 6. So in summary, she took half of the weekends available to her, and she exercised 16 of the 50 hours available to her on the midweek visits. And so that's about 32% on the midweek. Overall, a little over 40% of her time she's exercising.
Okay.
The communications have been a little bit difficult. For example, when we learned of the inpatient therapy of some sort that she checked herself into, Dakota was parked at the parking lot waiting for the exchange a little bit before 10, texting with Aspen, who was providing the third-party transportation for Taylor, and asking if parent time is going to happen. And Aspen responds, "Oh, you reach out to your attorney." And mind you, this is like 10 a.m. 10:41, I get an email from Mr. Ficklin informing me of the inpatient treatment and at Alpine Recovery Lodge, and that parent time would not be exercised.
Okay.
Now, we should have maybe been notified before that, so folks aren't waiting around in a parking lot for no reason. Communication beforehand would have been much more helpful. After that, I think that the exchanges have gone fairly well for the most part. There was some confusion on one of them where counsel was requiring or demanding that Mr. Mortensen use a third party to meet with Taylor's third party. And ultimately, law enforcement helped make sure that exchange took place since it was being refused, since Dakota was coming, as he always has, to these exchanges.
Was this the day that she said he appeared on the motorcycle?
Different date.
Okay, all right.
Yeah, different day. But I will speak to the motorcycle incident. I mean, it's interesting. A short ride on a motorcycle. Kid had a helmet. It is an e-bike, like a Suron type electric bike. Short distance, a helmet was provided. In fact, the helmet's in the exhibit picture. So it's strange that there was an insistence by Taylor that there's no helmet.
Well, the child is how old? 2?
He's 2.
All
Yeah.
right.
Yeah.
Well, we're not going to do that anymore. All right. That's one thing that'll come out of today.
Okay. Sounds like we got the partial ruling working already. All right.
Not with a 2-year-old. Maybe with a 12-year-old. Even then, there's no point in my view of, there may be some legitimate argument about whether or not that constitutes grounds for having him do a hair test, a drug screen, but as far as for basic safety, I mean, we generally require car seats or age-appropriate child restraints. All right.
Fair. Well, he will do that moving forward. He's gotten that from more than just Your Honor. So I think he'll be more wise in the future. I think he felt that the helmet was sufficient. It was, and with others, but nonetheless, we'll do that moving forward. Now, with regards to parent time, with Taylor only exercising a fraction of the parent time available to her, no input yet from Ms. Satterley. But I think more importantly, no disclosure yet of details about this inpatient rehab or documentation. I understand some papers were delivered to you this morning.
Well, I think there was a drug screen that she was willing to take. And from what I was reading, that may have come back. The results, Mr. Swinyard, did they come back? You're muted right now.
That's correct, Your Honor. That's one of the documents that was submitted today. When she had her brief stay at Alpine, she took a urinalysis test, and those results have been provided.
What was it screened? What was she? It's in the reports in the file. There's no way I could read all these documents today. All right.
I understand.
Yeah. All right. So where is that? Do you have a document ID number on that?
It is in it is in the pocket of the binder. So this is the document that was submitted for in-camera review.
Do I have that? Do I have a binder? I don't have a binder.
Okay.
When was that delivered?
My office delivered a binder about 3 hours ago to your clerk.
Okay. Well, do you know where? Downstairs in the main clerk's office or at W30?
I'll ask, Your Honor. I'll ask clarification right now.
Okay, let's go. So tell me what your representation would be. You're saying it came back negative. I'm asking for what it was screening for. 5-panel, 10-panel?
My client recalls it being a long list. She estimates a 10-panel test. And
all right,
it came back. They did a medical review as well and confirmed that the substances detected were consistent with her prescribed medications and nothing else.
All right. I'll just wait. Well, I need to see the verification on that. If you have it, you can upload it into the court file as a separate document during the hearing if you like.
My assistant just alerted me it was the main clerk on the first floor of the courthouse, so not your actual courtroom.
Why don't you call down to the protective order office?
Your Honor, I would like to have the opportunity to see that as well.
Yeah, I would too. Okay. All right. So let's come back to you, Mr. Shattuck. You can keep making your argument.
Thank you. I think in light of the parent time that has been exercised in part only by Taylor, it wouldn't be appropriate to expand that just yet. But we've also been seeking and asking for documentation about this inpatient treatment. Maybe what's been delivered to the court has something to do with that. Counsel indicated he got documentation from Alpine like 3 weeks ago, and or 2 or 3 weeks ago. My 3 might be a little far, but I haven't seen anything yet. He did email me just a couple hours before this hearing, giving me the opportunity to come to his office and look at them. And in light of the hearing, I don't have time to go spend the hearing with him, but rather would like to see what's been provided, and really looking for just a verification that nothing is going on that's being hidden. I mean, I don't know why it was mischaracterized.
I think this about it. I mean, there could be some privacy issues when it comes to medical records. I mean, on the one hand, on the other hand, it may be fair game where custody and parent time issues are before the court. At the same time, it might be appropriate to have, if we don't already have in place, to have a discovery protective orders in place, limiting dissemination of documents, and perhaps even that they can be viewed only by counsel and copies not be provided to the clients. That if the court is reviewing them, that they happen in camera and not filed with the court, like with the mental health evaluations, those kinds of things.
Certainly open to that,
Right?
Your Honor.
Especially with a case that has garnered this much attention.
Yeah. Speaking of that attention, we've been a bit dismayed that Taylor continues to make disparaging remarks about Dakota online. Dakota's not doing anything online, no social media posts or anything. And we provided the court with more than a dozen examples, one of which she alludes to she might be killed, and just nonsensical stuff that should not be happening. And I think it would be appropriate for this court to order both parties to make no communications with media or on the internet, social media, about the proceedings and about each other, because it just fans the flames of the dispute between these parties when we got third parties and friends who are seeing things, and that comes back, and this thing can just spiral out of control. And I think that the parties need to exercise better restraint. So
I did make some commentary about this at the last hearing. I know you weren't here at the last hearing, but I indicated that I was not really of a mind to restrain either party from their free speech rights on the one hand, but when it came to derogatory comments about each other, that's where I was drawing the line, because that can affect the child.
Yes.
And so to the extent that they weren't already in the orders, it would seem appropriate, and I do want to give Mr. Swinyard the opportunity for argument as well, but as an initial matter, it would seem appropriate and that it's fairly standard to issue orders restraining the parties from making any denigrating or derogatory remarks about each other directly to or in the presence of the minor child. And that can include social media, and it would also to extend to the parties encouraging third parties from engaging in the same kind of behaviors. And if they don't have control over that, then to remove the child from that environment. But I'm not inclined to just say they can't access media. These are people that have monetized their private lives and become a part of popular culture. And that's not really where I'm headed with this. All right.
Lastly, Your Honor, I think it'd be appropriate for the court to provide some clarifying order regarding the parent time exchanges. We've offered to perhaps have Taylor use a third party in the morning, because sometimes she changes her plans last minute, and that might be easier for her since she's got a larger support system with Family Local. And then Dakota could provide the third party in the evening, and then they can individually be present when the other party's third party is there for the exchanges. And that way there's no confusion, there's no insistence on third parties being there when that hasn't been ordered by the court, but some clarity there so we can avoid.
I think what I said, that either party could bring, you may want to remind me, Mr. Swinyard, too. I may have to go back and look at the other case, because this is the first hearing we're having in the domestic case. But I thought that I was authorizing each party to bring somebody with them. But we had mutual protective orders. So it would also be an indication that maybe I wanted it to be through a third party.
I think you used the word
I can't
may.
remember what the order said.
I think you used the word may, and I think with these two parties, we probably need a more firm directive because Dakota wanted to maintain the status quo of him always going and having exchanges with Aspen or
All right, what's his position on that again? He wants to do what?
have her provide the third party for the morning exchanges, and he'll provide the third party for the evening exchanges. That way, hopefully, have a little more advanced notice so he can make arrangements because he has less people to pull from.
I see. So yeah. Mr. Swinyard, let's hear from you on that.
Sure. Just on exchanges for now, or do you want me to?
Just on exchanges. Yeah.
Sure. So I think we can reach a stipulation that part of the issues that have been coming up over the last few weeks relate to whether Dakota has to provide a third party at all, or if Taylor is the one who uses a third party for every exchange, both legs. And we don't think the latter scenario is fair. It makes sense. What Mr. Shattuck just described makes a lot more sense than what Dakota's insisted on recently. The court's order from the June 1st hearing does leave a few things open to interpretation regarding this, but we absolutely think they don't need to be around each other at all, even if a third party's present.
Well, that's one of my huge concerns, right?
Sure.
Is that the fireworks won't take long, right? Okay.
So there was 2 days after the June 1st hearing, there was an agreement between counsel, between our office and Mr. Shattuck's predecessor, that the receiving parent would provide a third party to facilitate the exchange. And it's been difficult to get Dakota to follow through with that. But I think that with his acknowledgement today, with his stipulation today on the record, that is a big piece of the puzzle. And so either sending the third party, my client sending the third party in the mornings and Mr. Mortensen sending his third party in the evenings, I think that'll be very helpful.
Okay.
Doing the exchanges either at the parties' respective residences or the Smith's parking lot should be adequate as well.
You know, I think that there's given the number of declarations in the file from their various support people, that there's a bit of polarizing going on in the sense that it may be hard to find somebody who's not going to be taking sides during these exchanges and then trying to be a witness. And I'm certainly okay with either party bringing somebody with them if they want to. The bigger question was, should either of them be involved in actually handing the child off from one to the other, where they're in close contact with each other? Because I do think it's okay to record if that's what they want to do in case there's allegations that are made. But I did not want any third parties to be interjecting themselves in any way, effectively remaining silent and observing and not becoming an active participant, except maybe where it may be hand-holding from one car to the other, because we have a 2-year-old. We can't. Maybe Ms. Satterley can chime in on this in general, not even having met her client. I mean, the dynamics here are such that there's mutual protective orders, so they're not supposed to be within a certain number of feet of each other. Yet we also have a 2-year-old child who probably can't just walk from one car to the other with that kind of distance. And then there's certainly allegations are arising there's new allegations, another new police report from June about I believe it was an issue concerning whether a private investigator was involved in this case. So there's just given the nature of the dynamics, what makes the best sense. I'll come back to you on that. Maybe give you some time to process that while we're talking. Okay. All right, Mr. Shattuck, anything further?
I think briefly on the exchanges, I think we'd prefer they stay at a mutual location, a public location. The Smith's parking lot has been working fine. We'd like that to continue. May prevent the possibility of some issue happening. And in brief, we think that there needs to be more clarity, more disclosure about whether or not Taylor's in a spot where she should be expanding her parent time. But I think she's demonstrated with her choice to exercise less than half of it that she's probably not really got that as her priority. And we think the court should leave things in place as currently ordered until we get a report back from Ms. Satterley and
well,
documentation.
but
on
here's
her
the problem
treatment.
with that. All right, if Ms. Satterley isn't getting going because your client hasn't paid the fees and hasn't signed the paperwork, that's problematic. If you're just saying we need to hear from Ms. Satterley before we consider expanding parent time.
Well, I'm going to insist if there's documents he hasn't signed yet that should have been signed, I'll print them now and have him sign them while he's sitting here. And we'll get
Please.
this process rolling. So I'm not opposed to that, Your Honor. And even without input from Ms. Satterley, I mean, a conversation with the 2-year-old is going to be pretty limited. I think that what the parties have done is really what the court needs to look at. What we choose to do with the time available to us should tell the court the story the court needs to see to determine if it's right or not to expand.
All right. All right, let me turn to Mr. Swinard. We'll go back and forth here a few times. All right.
Great. Your Honor, I'll jump right into rehab if that's okay, or this stay at, more accurately, the stay at Alpine. The dates were June 19th and June 20th, so 2 nights. The purpose, as she's disclosed to counsel, was a professionally supervised transition to new mental health medications. She wasn't sure if there'd be a negative reaction, so she wanted professional support if it ended up becoming necessary. She did wait until after the June 18th visit, so she wouldn't miss that visit.
So you're saying she was feeling like the meds she were on wasn't working that well for her anymore?
Yeah, she wanted a change.
Okay.
She wanted ample support in making that change and making sure that it unfolded appropriately.
So when she checked in, was she under care of a psychiatrist during that weekend?
They just started with Taylor's people.
Those couple of
Taylor's
days?
side.
Yes, there was a team at Alpine and there's a psychiatrist on team.
Okay, all right.
She's basically saying she went to rehab
Okay.
because she wanted to get her meds
She also
changed.
timed it around Father's
For
Day.
one weekend, did you just
a
say?
week
Yeah,
that
2
would be
days.
spent wherever would be spending with Dakota. So she's trying to minimize the disruption to her parent time. That weekend would have ordinarily fallen on her rotation, but she scheduled it that way.
Let me ask this about it. Are you saying that she wanted to be under observation in case there were negative reaction to the new cocktail, shall we call it, of meds that she was being prescribed?
And Dakota's side argued she's only had used
Just to
16
help
of
you
the 50 hours.
understand, it is like with switching meds. Yeah, I wanted just like some extra help, like if there was a reaction, and then maybe like to try
Okay.
one, and if it didn't work, then to have someone just like recommend another one. So just honestly a reset and help with that.
All right. Okay. All right. I hear your position on that. Okay.
Counsel was informed, and he did request documentation, but in this case, Your Honor, you are very familiar with this record, and you probably recall the all too familiar leak pattern in this case, or someone tipping off or leaking information to the media. And my client had some real concerns about this, and it didn't take long for those concerns to be validated. Dakota's roommate and very close friend, Mr. Eaton, has been actively posting online about my client's treatment, including even making a false allegation that it was involuntary.
Well, here's what I would say about that too. I mean, if the parties are restrained from making negative statements about each other, I mean, this is the difficult part with this case where there's so much public interest, right? To what extent do they have control over third parties? Now, if we're talking about one's best friend, there could be a argument perhaps that they're acting on behalf of the party who's restrained, and that could theoretically be a violation. And I think there's probably some argument that's being raised about whether or not having a private investigator follow somebody around could be a violation of the protective order as well. But it's the way I'm looking at it today is if there's a belief that there's a violation of orders, or if you believe that we need to have specific orders, I'm willing to hear what that is. If it's a violation of an order, I think that's going to require a motion to enforce.
Understood. And the reason I bring this up, Your Honor, is to explain my client's hesitation to just turn everything over to Dakota. She had some very real concerns that have been, unfortunately, repeatedly validated over the last 3 months by Dakota about his discretion in holding on to and keeping that kind of material safe. So we've proposed different ideas here, including potentially allowing a neutral professional to review those documents. My client underwent a drug test at Alpine and has even offered to take another one and has taken one. She took that at Fastest Labs on the 6th, a nail test, a PEF test, and she's awaiting the results, and those will be released to counsel as soon as they're back.
Okay.
We're also,
and that was offered in the matter with Mr. Paul, right?
yes, that's correct.
Yeah.
That's correct. The court, at some point today, I thought you would have it, but it sounds like there might just be a disconnect between the clerks, which is okay.
I have it now, the binder.
Okay.
Yeah.
So in that binder, there is that 3 pages from Alpine, which counsel is welcome to review. At this point, we would
Did you not forward it to counsel before you gave it to me?
That's correct. But I did offer the
Let's
chance
be
to
careful
review.
about me looking at it then first. Let's have
And
a
that's completely fine.
conversation about that.
That's completely fine. I actually don't care, frankly, if the court reviews those documents today or not. The reason I submitted those documents is because I don't want the court to rely on conjecture, the smoke and mirrors that Dakota has to rely on. Well, she checked into a facility and she wasn't perfectly forthcoming with us, so it must be drugs, Your Honor. She's hiding something. And we don't want to be in a position where the court feels that it can rely on that. And so if the court is giving no weight to that, then we're fine if the court disregards those records for the time being.
I'm just want to be clear that there is another dynamic at play here, which is everybody's highly suspicious of each other. And anytime there's a blanks in information, the tendency is going to be to assume the worst. All right. So from my view, more information is better, but I also understand the concern about it potentially being disseminated and getting out to the public, such sensitive type of information.
We're trying to thread the needle, and we think, there are some options at the court's disposal that allow some transparency without something terrible happening, like a disclosure of this information. So that's what we're trying to implement here. And I appreciate the court's understanding of that.
I mean, there is a bit of an irony in the sense that they're public figures and they want privacy at the same time. So,
Dakota, scoot over.
Judge Mal pointed that out as well. I understand.
Can't see you.
A few comments regarding PCIT, Your Honor.
That's purposeful.
Alluded to in Dakota's status update, and I just wanted to provide the court with an update here. The court's June order compels the parties to comply with DCFS's therapy recommendations, and that includes both EMDR and PCIT. DCFS notified us that they expected the parties to proceed specifically with PCIT. So PCIT was the exact designation used, not some other label.
right.
Dakota, at the previous hearing, you may recall, proposed using the Children's Center, and we did not have an objection to the Children's Center. My client gave her authorization to the Children's Center after the June 1st hearing. And surprisingly, verbal consent is sufficient to begin that process, which she provided weeks ago. They did later request a written consent form, which she immediately provided the day after the Children's Center sent it to her.
Is this a complaint about something or just giving me information?
It's giving you information because Dakota's alleging that it's being stalled, that we're holding things up. And so I'm just providing the court with some background here.
Okay.
And my client has an appointment scheduled with their clinician today, in fact, this afternoon.
What's her response to the allegation that she hasn't been exercising all of the parent time that she's been
Yeah, you missed it, Rachel.
awarded up to this
She's only
point?
used 16 of her 50
Well,
allotted
there's
hours.
a few things that came up immediately. I mean, you may recall at the hearing from June 1st that I requested that the weekend rotation commence that weekend. And it turns out I spoke out of turn. My client did have a scheduling conflict over the weekend. And so that same day, the June 1st, I asked counsel, once I learned this from my client, I asked counsel, Mr. Shattuck's predecessor, if we could switch the rotation so she could still have her parent time. She wouldn't have to reschedule. Figured that would be fine it would be a reasonable request. But the request was denied. Once the request was denied, my client was able to reschedule her obligation and took that weekend with Ever.
Okay.
As far as the June 18th visit, Dakota almost alleges that the June 18th visit was missed. It wasn't. I mean, in his declaration, he kind of leaves it off. He says, well, there was a miscommunication with the exchange person. And he's implying that it didn't take place, but the June 18th visit did in fact take place. June 19th, again, that was a shortened weekend for my client due to Father's Day. And that's why she structured it there. So she did miss the evening of June 19th, or the overnight of June 19th.
Okay. I have another question too. If the judge grants the motion to set aside, if Judge Mao grants the motion to set aside, is it anticipated that we're going to be looking at a custody evaluation?
Procedurally, I haven't gotten that far with my client. I know that hypothetically that is a possibility. It's also possible that now that we have a private guardian ad litem, well, once Dakota pays, we'll have a guardian ad litem plugged into the case. Some folks see a custody evaluation being a bit excessive. When you have a private guardian ad litem, there's different opinions on that, but I don't have a great answer for you at this point, Your Honor, as far as that hypothetical scenario.
Okay. All right.
Few points on this police report, if I can, Your Honor. This is our Exhibit C that's in front of you. Dakota is, and this is part of our broader concern, he's using the exchange process. He's using the protective order. He's using this
Oh, hi, Dakota.
Unusual by their historical standards custody arrangement to exert control over my client. And
in what way?
He's using police now to do this. And I have multiple concerns and observations about the report.
Well, this was the one where it turned out to be a private investigator. Is that the one you're talking about?
Our Exhibit C has nothing to do with the private investigator. Our Exhibit C is Dakota's recent call to police because he claimed that Taylor was violating the protective order by Aspen communicating about parent time related issues. If you look through Exhibit C, you'll find a few strange things. There were
the one that I'm looking at ends in 2930. 226 BD 02930. Is that the one?
Yes.
Exhibit C? Okay.
That's our Exhibit C, Your Honor.
At June 26th. This was what? Last week?
That's correct.
The week before?
Very recent.
Yeah.
That's correct.
Okay. What happened? No.
If you look through the police report, one thing that stood out to me as a bit unusual are 3 separate calls between Mr. Shattuck's office and law enforcement, including an explicit demand from Mr. Shattuck's paralegal that law enforcement arrest Taylor. It is unusual for a law office to step into that role and badger law enforcement to arrest.
And where am I looking here? What page?
Sure. Let me get that for you, Your Honor. This begins on page 4.
It's not that.
4 of 11?
Right, yes.
And who's Katie?
Katie is Mr. Shattuck's paralegal.
Okay. So that's your investigator, Mr. Shattuck? Katie?
Well, that's
No, Your Honor. Katie's not an investigator. The AI report is in error that way. Bluffdale's going to issue a revised, corrected report because she never held herself out as an investigator. She is my paralegal. She did call the police because of the violation of the protective order having a third party stalk Dakota.
That's odd that a paralegal from the attorney's office would be the one to call the police, but okay. So let's hear what you have to say, Mr. Swinyard.
Sure. I find it odd as well. And I found it even stranger that there was the demand to arrest her. And I just think let law enforcement do its job. On page 8 of the police report, you'll see that Dakota told law enforcement that because a guardian ad litem is not in place, all communications had to go through counsel.
This is the issue where I think it was her sister that had been calling to try to facilitate the parent time. And,
texting. Yes.
Yeah, texting. Okay.
Yes. And they are allowed to do that under both parties' protective orders, because remember, there's identical protective orders here. Under both, they are allowed to use an agreed upon communicator, which they have been doing since entry of the protective orders.
Where does it say that the paralegal was demanding that Ms. Paul be arrested?
There's reference to a mandatory arrest, and I will get that for you in just a moment. It looks like it's on page 5, Your Honor.
This lawyer gives very junior partner vibes. Like, get to the point, my guy.
Yeah.
Final paragraph.
It's very different to say it's a mandatory arrest situation
Okay.
than to say, I demand
All
you
right.
arrested.
Additionally, Your Honor,
David
this
Gingrich
could have and should have been
Mike
avoided.
Marcini arrested.
One is Aspen is allowed to have those communications. And from the police report, it's very clear that very selective information, very carefully curated information and communications were provided to law enforcement. Only the texts from the very recent exchanges, totally out of context. It looks like nothing historical was given to police that shows that they actually did have an agreement by practice to use Aspen regarding parent time issues. Our Exhibit B in that binder in front of you, Your Honor, is 28 pages of communications between Dakota and Aspen since April 10th. And
You wanted me to go through all this now?
no,
Okay.
take
Ask
it from
for
me,
that.
Your Honor.
Aspen is her sister.
These messages are boring, which is the nicest adjective I can use in a case like this. These are exactly what we expected and wanted them to be.
All right.
They include everything from when parent time should take place, specifying length and days of parent time, where to meet, whether Ever had eaten recently, whether Dakota had sent shoes with Ever, because apparently he had forgotten, whether Ever had taken a nap, rescheduling parent time, Ever's sickness and mood, Ever's size of shoes, discussing doctor's visits and medicine dosage.
Usually I see these when there's something that you want to point me to that is a so-called
Yeah,
smoking
get to the
gun.
point. What is this?
When I'm
That's
pointing you
something
to
that the other side has said that you've documented that you want me to take into consideration.
it's the reverse here. I'm showing you a lack of smoking gun. And what I also find interesting is Dakota put himself in a very difficult position with law enforcement. I actually don't consider Dakota's communications a violation of the protective order. And I would never advise my client to go on a quest with law enforcement to badger them into submission, to pursue charges against Dakota. And I certainly wouldn't take that.
Well, I don't know that I read into it as much as you do. I'm looking at it and said the paralegal is simply advising that the law says this.
Understood. I think the broader point here is Taylor did not violate the protective order, but if she did, then Dakota did as well. And, counsel talks about exchanges going well. They are not going well. They could be going a lot better. And I think they go a lot better if we could cool it on the calls to police when those calls don't serve a purpose. It's been completely unproductive for him to engage in this. There's no reason to call police here.
So what are you asking?
For the court to take note of that, for the court to take note of Dakota abusing the current dynamic and improperly attempting to exert control over the situation over Taylor.
Well, how does it tie into what I should be doing, if anything, today with respect to parent time?
Sure. I think restoration of some normalcy is what we need. And I think that, again, this current situation,
what's normal, I guess is what that would be
it's a fair question.
Good question here, right?
Well, according to the parties themselves, as of last August, what normal was written in a stipulation.
70-30.
Okay.
So that is our request.
It's not getting 70-30.
I do have just a couple minor points, Your Honor. I know we are moving through this quickly, and I appreciate that.
No, I try to schedule these as my last matter of the day, knowing that they may go on for a while.
Understood. There is, and I know the court's already addressed the private guardian ad litem, and you hit the nail on the head regarding Dakota's very unfair request today of, Ms. Satterley's not fully plugged into the case, so the court's hands are tied. I think that logic speaks for itself here, considering his lack of payment. There is an interesting connection to.
Well, let me just see this. When did Ms. Satterley? Did you entered an appearance because you're attached?
Correct, Your Honor.
So you appeared. It looks like on
Oh, it's a
on
new
June
guardian ad
13th,
litem?
so it's been close.
Yeah, private guardian ad litem,
Been
but
3
Dakota
weeks,
hasn't
more or
paid her
less.
yet, so she hasn't done anything.
Okay.
Within 5 days of getting my order of appointment, we are supposed to do a notice of appearance. I emailed all counsel on June 16th with my engagement packet. I then emailed Mr. Shattuck again on June 24th and had communications with him yesterday.
Okay. All right. Well, and despite that too, I just want to say, I mean, I do have some concerns, and I see this in a lot of cases where custody is in dispute, that we have a lot of hearings that are the parties jockeying for position as it gets closer to trial, with the belief that the status quo may prevail by the time they actually get to trial. Don't know what to say about it other than that. There may come a point where I just say, I'm not going to make any more changes, get it to trial, and let's get it resolved. But I also recognize that there may be a lot of discovery left.
Sure. And I understand that dynamic as well, Your Honor, but my client's main concern today is not really trial position or anything along those lines. It's just getting more time with her child. There is an interesting connection between the guardian ad litem transition to this police report. Dakota did argue to police that because there was no private guardian ad litem in place, all communications had to go through counsel. And that's noteworthy for a couple of reasons. One, it's not correct, but also I think it does provide some explanation as to why Dakota still has not paid the private guardian ad litem.
Has your client been exercising midweeks as well?
Yes, she's been exercising midweeks, Your Honor.
All right. Okay.
Then how is she only
Couple just final points,
16
Your
out
Honor.
of 50
One is,
hours?
I mean, I think the picture should speak for itself.
What picture?
This is our Exhibit D, Your Honor, the motorcycle picture, and the court's already seen it. But counsel states that's a helmet. Okay, it could be. I don't.
Well, I've already ruled on that today. We're not going to do that in motorcycles anymore. Nothing with anything less than 4 wheels. Let's put it that way.
Understood.
All right.
I do want to point out, though, a couple of corrections. This was not a short cruise down the neighborhood street. This was almost 3 miles away from Dakota's home, either via Redwood Road or Bangor Highway. I certainly hope he didn't take Bangor, but Redwood Road is not much better. It's an extremely dangerous road. It's a full-size motorcycle, as you can see from the picture. He's taken it on highways with ever, in traffic during rush hour. His feet don't come close to the footrests. I think this was a terrible lapse in judgment on Dakota's part, and I think the court should take note of that. As far as
maybe don't bring your kid on a motorcycle
regarding social media use, I mean, obviously the parties have some pretty substantial, very important First Amendment rights, heightened by the fact that they both have an important platform here that they can use to educate the public. My client has taken social media herself. Dakota instead uses third parties. Through Crew, his very close friend and roommate and active documented participant in this case, he has leaked even more videos, or one video in particular from a few days ago that until a few days ago was not known to the public. It was a private exhibit in the parties' protective order actions. It was it's a brief video of the parties' altercation, of them having an argument back in 2023. The intent was obviously to embarrass Taylor.
They have to be, I mean, as you know, I mean, in not just limited to this case, they have to conduct themselves as if they're being recorded at all times, because it may end up as potential evidence in court. It's hard to say that, right? Behave in a way where you have to assume you're on camera 24/7, especially if they both have, or one or both of them have investigators involved. And so I will say this, as I indicated, I wasn't necessarily going down the road of restricting them from any social media postings. That doesn't mean that there isn't a reason to question the wisdom of engaging in social media postings.
Exactly.
Understood.
Right?
Understood. The reason, again, I bring it up is, I mean, the court has to be mindful, which I think you are, Your Honor, of the fact that someone can engage with the media, including social media themselves directly, or they can launder those communications through third parties, which is exactly what Dakota is doing here. And this is
Sipping
not some
Starbucks, bad
distant
look.
person
She did it last
who
hearing too.
randomly got their hands on something and went rogue and posted it themselves. No, this person resides with Dakota. He's an active participant in the case. He's very much aligned with Dakota, which is fine, but he cannot be out there. Dakota cannot be out there using this individual to leak information and potentially try to embarrass my client.
All right. Okay.
So as far as just in conclusion, Your Honor, we are asking for reinstatement of parent time based on the party's August 2025 agreement.
Oh,
His failure to pay the guardian ad litem's fee is, we believe, a delay tactic, so she doesn't receive an increase today. She has been the primary historical caretaker of Ever. He's asserted to the contrary. There's just no way he can prevail upon that, at least up through last fall.
That might require a full evidentiary hearing
Yep.
if there's that kind of factual dispute. So,
Understood.
Yeah.
He did have only a handful of overnights with Ever until last fall. Since then, it's been more shared, more in line with that stipulation I mentioned. And Ever, 2-year-old Ever, is still experiencing emotional distress because of these short visits, the transition. We are asking.
I keep trying to hammer home the point of getting these folks to work it out between themselves. That's the best way. If you're talking filing motions to privatize and keep the media away, best way to do that is to resolve it on your own. But if you can't do it, that's what we're here for.
Music to my ears, Your Honor. The last thing I'll say is, just in interest of returning to normalcy here, the court has expressed concern in this case, or the protective order case, at the conclusion of the April 30th hearing, that there could be a power imbalance, that Dakota may use certain restrictions to impose power, impose his will on Taylor, including issues such as supervisors at the time. And I think we are seeing that play out with crying wolf to law enforcement, of reneging on agreements related to exchanges, on being too restrictive on
Well,
parents.
I don't know. I mean, false allegations, making false allegations to police can be a crime as well. So if he's going over if he's crossing the line there, he may be exposing himself.
Understood. And
At least I can't stop people from calling the police. Certainly if you have a series of police reports that, I concluded there was no violation of the law. This one at least said that they didn't believe there was a basis to make an arrest. I don't know if it's being screened or not. But typically we don't get into violations of protective orders when we're just trying to arrange parent time.
right.
understood.
Yeah.
But I think I bring that up to illustrate that it's not working very well. Dakota is unnecessarily ratcheting up pressure and trying to intimidate my client. And I think that a more normal schedule will make more sense, as opposed to the statutory minimum. And so that's all I have for the court,
Okay.
Your Honor.
All right, let's go back to Mr. Shattuck, and if need be, I'll come back to you again, Mr. Swinyard.
He's a new lawyer
and
for
I'll
Dakota
make some
too.
rulings.
It's not the guy that did the first 2 hearings.
Thank you, Your Honor. At the June 1 hearing, Your Honor recognized that there were no current financial declarations and found that the parties needed to submit those in order for the court to determine the allocation of the cost for the guardian ad litem. And my client did that on June 5, and then the deadline was June 15. We finally got Taylor's on June 29, and awaiting that allocation was also part of why Ms. Satterley wasn't retained. We didn't know which portion the court wanted us. We're going to move forward with the presumption that it's 50-50 for now, unless you order otherwise. But having no direction from the court other than that it needed to make that determination,
Good.
we figured that it also hadn't been done, and we needed to.
No, I'm not, that doesn't fly with me. We had an order in place that said for now it was 50-50. It can be reallocated.
Did it say for now? I'm looking at it. I didn't see it 50-50, but if that's what you're saying now, we'll accept that. But the order doesn't contain that. But nonetheless, we've had Dakota sign the paperwork here today, and we'll have her paid.
Here's what the order says. If I'm wrong about this, I'll stand corrected. But what it said, 50-50, 1,500. So $200 an hour, 1,500 retainer, split between the parties 50-50. That's all it says.
Is that your appointment order?
Yes. That's docket number 70 in the file, signed by me on June 9th.
June 9. Okay. Okay. I'm sorry. I wasn't shown that. Nonetheless, we'll have her involved right away. I think most importantly, the court indicated on June 1st that Your Honor wanted to see what parent time gets used, to see if Taylor's exercising what's been given her. So you would consider possibly expanding it. And we've seen that she does exercise less than half
That
of
was
it.
mainly what I was expecting this hearing to be about, whether we were expanding parent time, adding restrictions, or doing nothing.
Yeah, that's why I remind Your Honor about that being your focus. And she clearly has not been exercising what's been given her. And it would be inappropriate for the court to expand further if she's not using what's already been given to her. Now, the council argued a lot about this June 26th police report. Certainly, we're going to see how it's clarified once they get the real report and the AI one is replaced. It's not unusual for a law office to be involved when a protective order is violated. And so that's why my office was.
It's a little odd to have someone from your office be the one to make the phone call, but I don't know that I've never heard of that before, but that's all I can say, right? It just
Well,
seems
it's either you instruct the client to call, which is typically what happens, or if
typically they're calling on their own.
Typically.
Right. Yeah.
Yeah, typically. But I don't think it's per se wrong for anyone to recognize a violation of an order and to make it known.
Okay.
Now, the timing of this inpatient therapy is very telling. Counsel's argued, I think, 3 times that Taylor carefully planned to have this therapy or this inpatient from the 19th to the 21st during a time that wouldn't interfere with parent time. Well, how about an off week or Monday through Wednesday, any week, instead of on the day she's supposed to take parent time and without almost any warning? So it is highly suspect that perhaps it was some immediate need or some mental health issue. We don't know yet because we haven't seen any documentation. And so I think it'd be premature for the court to make any changes.
Well, I do want you to be able to look at it, but I don't want you to be able to disseminate that information. All right. So I talked about, and I want that to be part of the order today, that we have a discovery protective order case. You probably both have standard language. Well, you can compare that language and see if you can come to an agreement as to what that should look like. But typically it would be for attorney's eyes only, in the sense that, well, let's put it this way. The clients could also look at it, but I don't want it to be disseminated to either client, except she already has a copy. It was her report. I don't want a copy in Mr. Mortensen's hands of her
This is very common. These
her
orders.
records, nor do I want her to have in her hands copy of his records. All right. But I do think they should be able to look at it. I mean, I think that's important for strategizing and whatever else there may be, concerns that may be raised on the one hand. But again, my concern is making sure that it's limited to the use in this case and that it's not being disseminated. So they can fall into hands that might end up. Now, it can be certainly problematic as well if one of the parties is leaking information to the media. I think that's probably a good restraint to have as well, that the parties at least be restrained from doing that. Now, given the history of this case, I've also, I've seen that some information may get out anyway. Let's just put it that way. I mean, it is an open hearing. There are grammar requests that can be requested by media, et cetera.
Yep.
Right. I'm sorry, I cut you off.
Your Honor, I think I was about done there with my response. And so I'll go ahead and just, let me just check my notes here. Oh, yes, a couple more items. The third party communication to coordinate parent time shouldn't be negotiating. parent time, negotiating terms. And that's part of why there was an issue with some of these communications. Dakota didn't leak the domestic violence video from 2023. Many
I know.
people,
I'm sorry, you're saying he did or he did not?
he did not.
Yeah, I know. I knew there was a factual dispute about that.
Yeah, well, and my point is, counsel keeps alleging that Dakota's leaking. He's not. He's not the one posting on social media. Taylor is, and so
Yeah.
we're abiding by the rules, and she's still disparaging. I don't want to waste time on motions to enforce. We may have to, but I think it's important, and I would ask the court to instruct the parties not to disseminate. And I think you've already indicated you're reluctant to do that.
No,
their First Amendment rights.
I don't want them to disseminate information like that's being used in the case. I just don't think that's a good idea.
Right.
All right. That's so they show up to a parent time exchange, for example, and it's being recorded for protection against false allegations, and then suddenly it's online.
Mhm.
Right. I don't want them posting about each
somebody
other
do that?
online.
Okay.
But if they want to
Not about
post in general,
exchanges.
I don't have a problem with that. I just don't want them disparaging each other. I don't want them to be posting videos of each other.
Well, they're not, because they're not seeing
mean-
each other.
How detailed do I need to get with this?
Very.
Apparently very, but we'll put that in
I should be a
order,
lawyer.
Your Honor, that you don't want them posting about each other online. And I'll defer for your ruling, Your Honor, on the remaining issues.
All right, Mr. Swinyard, anything else from you?
Only a couple things. I think Dakota's, by pointing to the private guardian ad litem order, well, we don't know how the court was going to allocate it. I think that's a new reason that he's giving today. I think the real reason that, based on counsel's opening comments on this at the start of the hearing, was that it just slipped through the cracks. So that happens. Yeah, but I think that's the real reason it slipped through the cracks. It's also possible that there's some intent here to stall.
This guy is not good.
Limit Ms.
Maybe.
Satter's voice today.
Maybe it was just but I am concerned when I hear from Ms. Satterley about multiple communications and it's still not done by the time of hearing.
Right, I was as well, concerned and frustrated. As far as the visit to Alpine, in hindsight, it was a 2-night visit. She could have structured that around parent time with 0 interruptions. But what I alerted counsel to is that she was budgeting maybe up to a week, not really knowing exactly how long it would take. And she checked out voluntarily after 2 nights. So just wanted to clear that up.
Did she miss parent time as a result?
Yes.
There was one parent time slot that was missed. And it was a shortened weekend because of Father's Day.
And was it conveyed to him in advance so that he wouldn't just show up and be waiting around for no reason?
It was conveyed to him at the start of parent time. And
I
so
see.
I concede more advance notice would have been appropriate, Your Honor.
Sure. Yeah. And we'll have that in order too. How about that?
No objection, Your Honor.
All right.
The last point I'll make regarding co-parenting communications, again, I don't understand Dakota's crusade on this point. If the court reviews Exhibit B, you're not seeing negotiation. You're not seeing a violation of the protective order. You are seeing both Dakota and Aspen engaging in voluntarily and engaging in routine parent time related communications. He's been doing this for 3 months. And then on the figurative eve of a parent time review hearing, he tries to spin this by giving very limited information to law enforcement to try to bolster his case today. Oh, it's a violation of a protective order. I mean, don't worry about the history here, officer. Don't worry about the actual.
He doesn't listen to the judge.
Between Aspen and Dakota.
He doesn't hear what the judge wants to know about.
It's a fairly lengthy report, and I think that the police have been involved enough between these two. This is Draper again, is that right?
This particular report is from Bluffdale PD.
Bluffdale, Draper. I mean, I think they're aware
Are you crocheting?
of the history at this
Rachel?
point.
I'm doing a lanyard.
But there's no way they're going to be aware of the historical communications, the 28 pages of communications between Aspen and Dakota, which should have, in all candor, had been presented to law enforcement.
Because law enforcement's going to read 35 pages.
Understand if there really was a violation. And I think law enforcement will get to the bottom of it and come to the correct conclusion here and determine there was no violation. I just find it strange that he's pointing the finger at Taylor when he engaged in the exact same conduct, even referring to Aspen. He's talking about you guys, or he's directing multiple messages to you guys or to my client on parent time related issues. So I don't, again, at this point, I think he needs to be more careful and use better judgment in when he calls the police and launches an unnecessary attack on my client. There's just no reason for that here.
You think the judge is going to say you can
All right.
only call the police under certain
Well, I
circumstances?
think that certainly if
Come on.
the police determine that there's a false report being made,
Yes.
that's going to be an issue for him or for whoever's making a call to the police. But I don't think I can restrain a party from contacting
Calling the police.
if they have a good faith
No.
belief that there's been some sort of protective order violation.
Your Honor,
It turns-
I have one quick question. I think for the benefit of both
Let's-
parties.
Go ahead.
Thank you. I wanted to make sure we had your thoughts on this or direction. My understanding is if either party is to use a third-party detective or private investigator or someone to stalk or to follow, that would be a violation of the protective.
I don't know
Always.
what that is. I don't know that that's a violation of the protective order.
Usually
honestly.
is.
Yeah. I mean, I think that there's, but I would want a motion on that and have an opportunity for that to be briefed, and because there may be provisions in the code that need to be addressed.
Oh, you'd want a motion before someone
Yeah,
does?
for example, if someone uses a private investigator, does that constitute stalking, right? And I think the statute may have something to say about that.
Okay, if we choose to go that route, we'll file a motion about it beforehand.
All right. So let me make some recommendations for today. One is I do think that if there's not going to be exercising parent time, that there should be some communication beforehand so that people aren't unnecessarily having to waste time, for lack of a better way of putting it. I already indicated I don't want the child to be transported on a motorcycle. I want it to be in an enclosed vehicle.
How old is this kid? 4?
With
2.
full
Two.
safety restraints, age appropriate child safety restraints. My recommendation further would be no online postings about each other, in the sense of making no denigrating or derogatory remarks about the other party directly to or in the presence of the child, and also in general in public forums such as social media. That doesn't mean they're restrained from posting and being a part of social media. I think that's part of how people were making their living, in fact, in this matter. TikTok, Instagram, that sort of
He
thing.
knows TikTok. Good for
And
him.
but I want to draw the line at when it comes to making negative statements about each other. Eventually, all this could come back to the child, and this is where we're trying to shield the child from this conflict, even later on down the road, many years down the road.
Yep.
Next is I'm not really going to make changes to the order today when it comes to third party presence. I mean, it sounded like there might have been a stipulation on that, Mr. Swinyard. I think either party can bring somebody with them if they want to, but the responsibility to have a third party there for effectuating the exchange would be her in the morning and him in the evening. Is that what we were talking about?
That's
Or
correct. And I want to make
The parent, why don't we put it this way? The parent that's retrieving the child would be the one responsible for having the third party with them to facilitate the exchange.
yes.
Does that work for your client too, Mr. Shattuck?
Yeah, that works.
Okay, all right.
I do want to make sure that we're not expanding that unnecessarily. I believe the court would have power to make a carve out in the protective orders to allow the parties and third parties to be at exchanges, but we're not requesting that at the moment.
I just don't want them to be alone at the exchanges so that they have to do it themselves, because I want them to stay away from each other. And I want there to be at least one person there to facilitate the exchange but not to stop the other party from having somebody else there too to document.
Your Honor, I just don't want Dakota and Taylor at the exchange together, even with third parties there or not. If the
Oh, I
receiving
see.
parent,
Okay,
the
if you want to
receiving
send
parent-
somebody and not appear to do the exchange, that's
Exactly.
fine.
I
don't-
thought
I would
I
not
thought that's
like
what
these
was
folks-
happening.
But the parent who's responsible to have the exchange person there will be the retrieving parent,
Retrieving parent.
not the relinquishing parent. All right?
Yes,
All right.
great, thank you.
And we're still going to do that at the Smiths, right?
Yeah.
I think she's open to either Smith's or personal residence since we're using third parties, but we can work that out with council. I think we.
Jesus.
Okay. In the absence of a stipulation, we'll just keep that at the Smiths for now. That's where it's been happening, right?
Great, thank you.
All right. And then I talked about a
Who are the
discovery
Smiths?
protective order. I do think
it's
that's
a-
appropriate because we're dealing with
assuming
some
it's a
sensitive
Park or
documents
something?
here.
It's a public place.
And then the PCIT therapy that you brought up, that was just for my information, it sounded like, right?
Yes, just
All
to
right.
show compliance, Your Honor.
All right. So now down to the question of what to do about actual parent time. I am concerned that I don't have information today in large part because there hadn't been the ability of the guardian ad litem to have input. I think there would have been plenty of time for the guardian to at least to conduct initial investigation after their appearance had this happened. So I don't have that information, and it's I wish I did, but I think that I also don't think that I also find credible though that the missed parent time in part was due to an initial scheduling issue, and that since that's been resolved and schedules have been rearranged, that there's been more consistency with exercising the parent time. I'm going to, for today, expand for the weekends, just to have those weekends carry over through Monday morning and as opposed to Sunday evening.
Oh.
I'm not going. I've said
So
from the
one extra
beginning
day.
about taking baby steps. On the one hand, on the other
No,
hand,
it's just an overnight. She already gets them through Sunday evening.
I think that my concerns about whether or not the child would be subjected to some risk of harm would be abated by keeping the two parties together. I think that's happening. I still want to set it for another review. I'm not at a point yet where I want to say no further reviews, but for now I'll extend the weekend time. I'm also contemplating perhaps if there's no further issues, I think legitimate issues. I think a lot of what I've been received are complaints about the other party that don't necessarily go to parent time, but as to whether the parent time should be expanded, such as hiring private investigators. I just think that there's a lot going on here that's designed to inflame the passions of the finder of fact. But I'm not a jurist who hasn't been exposed to the court system in the past either, so I can filter some of that out. I mean, I hope that the parties can keep their pleadings relevant to the issues at hand. That's important moving forward. In some ways, I get a feeling like there's a desire to keep the drama going, that it keeps it in the news, that it keeps them relevant in the social media context. So I'm concerned about that too, and how they can have the effect that can have later on down the line with respect to the child who's probably still too young right now to have an understanding of the full picture of the dynamics between mother and father. I still want you to keep working on this case. So far, I think you heeded some of the advice that I provided for you, got into mediation. I really did truly appreciate you trying there. I want you to keep working at it. And another thing I want to say about this too is listen to your guardian ad litem. I've known Miss Satterley for a long, long time. I trust her. And that doesn't mean we that any of us get it right 100% of the time, but listen to what she has to say, please. And I think we'll have some better information when we come back. I'd like to have this actually be not that long out, closer to the last hearing was in the beginning of June. This is the beginning of July, so we went about 5 weeks out, right? the last time. I'd like
Yeah.
to do that
June 1st.
roughly the same. Come back maybe first week of August. If I have an available
First week of
slot in the
August is 3
afternoon.
weeks away.
Yeah.
It's July 8th. If they do August 1st, that's
On what
literally
day?
3 weeks. 24 days, 3.5 weeks.
I can go 3 o'clock on August 3rd.
Your Honor, I'll be in a judicial settlement conference that afternoon.
This Saturday is on top of things.
She said basically nothing.
How about the 5th?
I'm available then.
What time, Your Honor?
3 o'clock via WebEx. Is that right? Okay.
I've
3
got
o'clock via WebEx.
I've got a 1:30 in person in Provo. Do you have perhaps a 3:30 or a 4? It might make it doable.
Try not to go that late. What about Thursday? August 10th at 2:30 we could do.
I can do that, Your Honor.
I'm available then, Your Honor.
And that works for us as well. And
Okay.
I do have a question once we have scheduling out of the way, Your Honor.
Okay, well, we'll reset it for a parent time review for August 10th at 2:30. By then, you should also have a ruling, hopefully, I don't know, maybe not. You don't even have a hearing date set yet with Judge Mao, so we still might not have a
I don't understand
resolution on
what
the motion to
procedural
set aside
posture
the
of this case
stipulation.
is.
Certainly, if that's denied, then there may be big changes coming. All right.
And Your Honor, one observation.
Great.
As
More talking
we've
from
tried
this
to
guy.
articulate and present in our filings, exchanges have been challenging here, and we'd like to simplify those as much as possible. And we think that a logical way to do that would be to transition the Thursday day visit to an overnight. That way there's a nice clean block instead of that back and forth.
I was thinking about that today. I'll be thinking about it at the next hearing.
I
I
don't
mean,
get
we're talking, what? 4.
so Thursday drop off and
A little
Monday
over 5
pickup.
weeks out.
No, it's just Thursday for the
I'm
day.
still thinking about that, expanding midweek.
But then she has to drop them off,
midweek
or they have
visits
to drop off
overnight.
the
That's
next
why I
day. It's
asked
the
about
weekend. It's every other
whether
weekend
she
and
was
one day during the
exercising her
week.
midweeks.
Yeah, that's not that uncommon.
Okay.
Oh.
All right.
Understood.
Okay.
We'll prepare an order, Your Honor.
All right. Thank you, everybody.
Thank
Good
you.
luck.
Thank you.
Keep working on
Bye.
it, please.
Okay.
Thank you, Your
Thanks, Your
All
Honor.
right, thank you.
Okay. All right.
I'm doing a lanyard. I just got back from adult summer camp, and we do all
I was
sorts of.
going to say, like, as Rachel Juarez makes a shawl for herself.
You think I can crochet?
I'm
Good
like,
one.
I thought
Yeah.
you were. I literally thought you were crocheting.
No, it's like a cute little lanyard. See?
Okay. Hold on here.
All right, I'm putting away my arts and crafts.
I was going to say, thanks for joining us.
That was boring.
Yeah, it was really boring. I'm stunned that like the biggest thing that we've been talking about was literally glossed over, other than, hey, stop talking about each other. Like, does one side have to file a motion or they're in contempt of court? Like, why isn't this being given more attention to?
I don't know. And what I didn't see their opening salvo. That's the problem. Was that a big part of his opening statement?
It was Dakota's lawyer brought up two things when he spoke first. She's used 16 of her 50 allotted hours.
Which is like, how did that not make a bigger impression? That's nothing.
I know. That's what I don't get. And then he brought up the inpatient therapy. And then he brought up, because they didn't have any information. They still don't know any details because of, paperwork and stuff like that. About
what she said makes zero sense, because you do not, if you change your psych meds, you do not know if they're working within 24 hours, right? Like, I mean, I guess I could theoretically, depending on what medicine she's talking about, understand like, oh, I could have a horrible reaction and I need to be under the supervision of a doctor. But if you're on like antidepressants or like anti-anxiety meds or something like that are controlling your mood and you want to switch them, you cannot do that in 24 hours. You have to titrate down. You have to titrate up. Like, I mean, that's ridiculous to suggest that like, oh, well, let's see if they're working or not. and we'll know by tomorrow. Like, what?
Yeah, the thing that I got from her lawyers was him saying, well, she allotted because for a week, but then after 2 days, she voluntarily decided to leave. So I don't know enough about meds, but
Which is worse than, I mean, that's bad.
I take blood pressure pills. That's about it.
Which ones?
Is that atorvastatin? Atorvastatin, lisinopril, blood pressure, and cholesterol pill. That's what I take. Yeah,
I take amlodipine.
And I have amlodipine. Yes, that's the other one.
Yeah.
So yeah, his lawyer went first. Yeah, the guardian ad litem came on and said, I really have nothing to report, Your Honor, because I haven't talked to anybody because Dakota hasn't paid me.
Okay, so I was confused that whole time. I thought he was ordered to pay for it. I was like, how is that possible? She must have more money.
No,
but I guess they were both supposed to pay and he didn't.
She paid her 50%, and it sounded like based on that, they said 1,500, 50-50. So I guess they both owe $750, which is exactly the same number, which is exactly the same amount that Ravgen needed to collect from Laura Owens and Clayton. That was 750 other.
Boy, that's crazy, right? To run one test versus like be a guardian ad litem.
Yeah.
Yeah. So look, this is a common stall tactic. Like, oh, there's been wires crossed about paying the guardian. Oh, they can't do their report. But we don't know if that's the case. It could be an oversight. It's not like it's been 6 months or a month that she hasn't gotten paid. It sounds like
she just came on to the case because this wasn't the ad litem that was at the previous 2 hearings.
Right. And I wonder why they went to a private guardian ad litem. She also looks like a tough cookie.
Yeah. And she seemed like a friend of the judge because he said, listen to Miss Slattery,
which I think is not good for Dakota because this judge clearly has a favorite.
Oh, he does? Okay.
I think so. Yeah.
So here's my question. So the next review, like, how long do these reviews? Is this judge just going to keep saying, let's meet every month? When does this end?
This is super crazy. This is nothing like what we see here. What's even weirder to me is they're talking about preparing for a trial. What trial?
Is it the trial to determine like a judge is going to lay down, okay, this is now the custody? That's got to be it, right?
So I think what has to be happening, I think, from what I've gleaned, is that right now, their stipulation, there's no judgment, right? All they have is like an interim stipulation. This dates back years, and there was no judgment in their paternity matter. So there still has to be technically, even though they had this written agreement, a written agreement is not a judgment just because you reach an agreement. It can be, that's a temporary thing, okay? Now, some people will just do that and never come back because if they've reached an agreement, they've reached an agreement. Nobody has to go to court necessarily, right? Especially if you're pro se and this is not a big to do and it's not a big, contentious situation. But I don't know what they're going to trial on. It's not the restraining orders. That's done. He has issued permanent restraining orders. And by permanent, I just mean long-term. I don't mean forever. But he issued the 3-year or the 2-year, whatever they were, restraining orders. The cross restraining orders are done. Those are final, right? They can be renewed. I mean, it does harken back to Laura Owens, but like they can be renewed when they expire, but like there's no need to have a trial on that. That already happened. So I think the trial must be in their custody matter, their paternity suit from 2.5 years ago or whatever it was.
Yeah. So I guess my question is these parent time hearings, this is what these are. We had one April 30th, we had one June 1st, July 8th, and now we have one August 10th at 2:30. This is going to be the 4th parent time trial or parent time hearing. When does this stop? And the judge just says, does he say, I don't want to do any more parent time hearings. You guys either settle it yourselves or you're going to court or you're going to trial?
I don't have a clue. We don't have this here. We don't get this here, right? We don't have time in California. I mean, I think it's lovely that they have the time for it, but in California, you can file a motion to modify custody, even if it's only temporary. The court will hear you. And like sometimes they will say, okay, well, we have a status conference in 6 months. And so if you want to file something in advance of that, we can review custody at that time. But like this whole, let's come back in 4 weeks and like chat about custody. That doesn't happen.
And they never even, and this was about a parent time hearing. And there were just so many other things that were
that's common. That's super common.
that they didn't even address what the
Oh
hell
yeah,
they were there for.
these people that are in this like massive fight that they're like, well, he filed a false police report. Well, she's having me followed by a private investigator. And by the way, in California, I tell all my clients that hiring a private investigator can be considered stalking and can be considered, it's absolutely a danger of being a violation of a restraining order. But I tell my clients, even in advance of that, hiring a private investigator could get you a restraining order because it could be considered stalking. Like that's a whole new sort of like place that this stuff is going.
And we didn't even get anything other than, hey, no more disparaging remarks. That's not going to stop her.
Of course
I guarantee we're going to get something before August 10th, if not numerous things from both of them, not just Taylor. Dakota just does it through his roommate. He just does it through crew. She does it on her own.
Yeah, the difference is like you're kind of, I mean, you have to kind of weigh what's happening, right? They don't want people disparaging the other one online, right? Like it's if to go through 3 different channels, first of all, it's impossible to prove. But second of all, it's actually different than just the parent doing it. It really is, you know?
What, having crew? You're saying having crew?
Yeah.
Post
yeah. Like it's a different issue for the judge to confront, because it's one thing to tell these parents, you cannot disparage the other one online. It's another thing to turn this into, I'm not saying it's any better for him to be doing if he's doing it, but it's another thing to say, like, I'm going to start policing the social media accounts of everyone that everybody knows. And I'm going to decide if somebody too close to Dakota posts, well, that might as well be him. Like, you can't do that in a family court, you know? But this notion of like, well, she has a First Amendment right to post. I mean, yeah, she does, but she also doesn't.
I was understanding what he was saying. Like, she's allowed to, from what he said, the impression I got was, yes, First Amendment right to post.
Of course.
About your life, about brand deals.
Of course.
Stop posting about the court and this custody and him.
Yeah.
So that's what he was saying.
There's the First Amendment, you know, people forget what the First Amendment is all the time. Like when children say, like, I have freedom of speech. It's like, not in this household, you don't. Like the government might give somebody freedom of speech, but like you don't have the right to say certain things to your teachers without being kicked out of the classroom. That's not a First Amendment issue. It's the same thing here, right? If you are making derogatory comments about the other parent, the extent to which the First Amendment protects you from having custody change, it is like, it doesn't. It's, I mean, I shouldn't say it doesn't, but they're separate issues.
It's one of my biggest pet peeves when it comes to First Amendment talk. Like,
when everyone's like, I have a First Amendment right.
I have the right to free speech. Yes, you do.
You absolutely do.
But, you know, it doesn't mean doesn't come with consequences, you know.
Right. And
free speech doesn't mean free of consequences. And
this is rights you have vis-a-vis the government. The Constitution regulates the people's relationship with the government. Yeah. It does not regulate. Now, there may be other rules that stop your employer from punishing you for certain things you say, like discrimination rules. Yeah. But you don't have a First Amendment right vis-a-vis your employer. Yeah. That's not a thing. It's you and the government. They can't arrest you for saying certain things. Yes. You know? That's
First Amendment has to do with the government impeding on your freedom of speech.
Correct.
But and if you think the First Amendment means you can say whatever you want, okay, then just go up to your boss tomorrow and tell him to fuck off and see if he fires you.
And tell him you're going to kill him.
Freedom of speech. I can say whatever I want.
Yeah, I can say whatever I want. Well, that's true. The government probably cannot jail you for telling
the government's not going to throw you in jail for telling your boss to fuck off.
Right.
But your boss will fire you because freedom of speech does not mean freedom of consequence. But so many
there are limits. Like you can't yell fire in a crowded theater. You know,
can't yell bomb at an airport.
Yeah, and you can't defame people.
So I didn't. I mean, I guess this was just with the recommendations at the end. Nothing was crazy. So from what I gather is right now their parenting time going into this hearing was every other weekend and 1 day a week. We didn't get to hear at any point during this hearing what has been the 1 day a week that has been really, designated for you guys. Have you been trying to keep that day? I mean, I don't know if it was, but
I think they were just saying it was Thursday.
So let's just say it is Thursday.
Yeah.
And it's Dakota and it's Taylor's weekend that weekend. She would get Ever all day Thursday then have to drop him back off, or exchange Thursday night, goes back to Dakota, stays with Dakota Thursday night, and then another exchange sometime Friday, and then she gets him.
I don't think she has 2 overnights.
I thought it was what does weekend and 1 day a week mean? Friday,
so
Saturday,
weekend
Sunday.
usually starts Friday evening, but I don't think she's had 2 overnights that's now being increased to 3. That's more than 50 hours. It seems to me that she probably, in order to get to the 50 calculation, you've got to.
Yeah, he didn't break that down. He just said she's used 16 of her allotted 50 hours since we last met.
That's wild.
We'd have to sit there and break down.
No, she's got to get custody sometime Saturday, and it continues till the end of the day Sunday. Otherwise you'd have 50 hours in 1 week, because 2 full days is 48 hours. So if she really got custody Friday evening and relinquished it Friday evening, 1 week would be 48 hours.
So you're saying the overnight is Saturday morning to Sunday night,
or like Saturday evening to Sunday evening? I have no idea, because
we don't know.
But it can't be more, or there wouldn't be 50 hours.
50 would seem low in the last 5 weeks. But to use only 60. So and the day during the week, it's not.
During the week, it's just the daytime.
Just daytime, 10 to 8 or whatever. And then
it can't be 8 to 2-year-old. It's got to be like 10 to 5.
This recommendation at the end of this was, whenever they start, you seem to think it's Saturday evening into Sunday night.
Later on the day Saturday.
That's now going into Monday morning.
Yeah, so now she gets overnight on Sunday now too, instead of dropping him off at 5 o'clock on Sunday.
So it's not doesn't seem like it's a major change. She didn't get the 70-30 clearly that her lawyer has asked for all 3 hearings.
And if she's only using 16 of her 50 hours, it would seem like she's the kind of person who would be like, oh, I don't even want the overnight time anyway. I don't want to have to deal with bedtime and waking him up. And, that's just wild. And what's this thing about the schedule? I have a scheduling conflict. What?
There was just so many things about this that were brought up, like all the things that we thought would be brought up, but then they were never dove into.
Yeah.
I wanted a breakdown of the judge to say, Miss Paul, you've had 50 hours and you've used 16. Why? Let's go over this. Why didn't you get him on this time? Why didn't you this week? Let's go into week 2. Since our last hearing, why did you only use 16 hours? Yeah. So I guess that's why you seem to think the judge favors her, because it seemed like you would hammer her more for why did you only take 16 out of.
That's a shocking calculation. It's if they were up there saying she forfeited 10% of her time. She only used 45 out of 50. I can see the judge being like, what the fuck? Okay, fine, whatever, But she only used 1/3 of it?
Yeah.
That seems crazy.
Yeah.
And why are you increasing it? Because it really starts to feel like she just wants what's convenient for her.
Well, there was a story that came out apparently right before we went live, that, let me see if I can pull it up. Someone said on TMZ posted a story today right before the hearing in regards to Taylor. Oh, did they just post at 12:55? Dakota claims sneaky text with her sister. Taylor disputes. Okay, no, this is taken from the trial that we just watched, or the hearing we just watched. God, there was a story that came out, so I'll just need to scroll and find it. Oh yeah, Taylor, Frankie Paul's ex-boyfriend Dakota, she thinks our son's cries are annoying. This came out right before the hearing started. In court documents obtained by TMZ, Dakota's legal team filed a motion asking the judge to set aside a previous stipulation ahead of Wednesday's hearing, attaching dozens of exhibits they say contain text conversations between the exes. Well, first off, I thought they weren't allowed to have any contact.
Right. So these must be old.
Okay, yeah, maybe they are. According to the exhibit titles, Dakota alleges Taylor said Ever's cries for him were annoying, admitted he didn't deserve the domestic violence, planned to sabotage Dakota, and mocked his safety concern. Other exhibits are described as showing Taylor asking Dakota to disparage 2 unidentified people, baiting him during multiple exchanges, admitting she disassociates, provoking him over a medical issue before attacking him, sending dozens of unanswered texts between midnight and 4 a.m. That's the thing that I posted on my Instagram account a couple months ago, sending graphically intimate messages about Dakota's lip tattoo and cycling from arousal to anger in her texts. So this was the stuff that the judge said, I've got a binder here, and I just got this today. So what am I supposed to do?
Yeah, and by the way, you didn't give it to the other side. Like that is the first.
Well, that was her side. That was the one. Yeah, that was her side.
Oh, right.
They gave the binder.
Oh,
yeah.
what a junior. Yeah, that's not junior partner vibes. That's first year associate vibes. Like the first question a judge asks when you show them something is, have they seen it? Yeah. Literally every single time. Have they seen it? Have they seen it? Like that was wild to me.
There were some questions that came up. Oh, by the way, Smith's is a grocery chain in Utah.
Oh, okay. I thought they were exchanging at their friend's house, the Smiths.
Yeah, no, Smith's is a grocery.
And by the way, very weird that she wants to move it to the houses. Like,
why?
And what I really wanted to hear more about is if these exchanges are not going well, why?
Especially since neither of them, it's not like they're showing up and getting into an argument. Her lawyer even said, I don't want them, even with third parties, I don't want both of them to be at the exchange.
Yeah, which by the way is not a bad idea.
I thought that's the way it was. I didn't think because they have
there's really no need for
there's
either
a protective order
go.
for both of them against each other. I just assumed neither of them were showing up. He didn't say that that's what's been happening. He just said, so I don't know. That's where it was confusing. I assumed that every child exchange since the last hearing, they haven't both been at, because what's the point? You have a protective order.
Yeah, I mean, it's a little hard, especially with a 2-year-old, to like give them to somebody else, right? But
I mean, I think one of the parents obviously is there every time, but I don't know. Maybe it's like the Smiths parking lot. They show up over here. Dakota parks 100 yards away, and
no, it's an exception.
Taylor's in the car and Dakota's in the car, and
it's an exception to the restraining order. When they exchange the children, that's usually an exception to the restraining order. So like there are plenty of cases where there's a restraining order in place, and the 100 yards doesn't apply when they're exchanging custody.
Do we know if that's the case in this case?
I would assume it is, because I would assume that's what's in the forms. But like they're not sending Ever running across a parking lot.
I thought it was Dakota shows up. Well, now he's saying what the parent retrieving needs to supply the third party.
Right, the parent picking up the child. Yeah.
Yeah. So Dakota has Dakota is giving the child to Taylor for a day or the weekend. It's her time.
She needs to bring
somebody. Dakota can
come
by
if he
himself.
Wants. Yeah, he can come by himself.
He's got Ever on his motorcycle.
I mean, what a moron. Okay. Like, look, that's a stupid thing with a 2-year-old anyway. Yes. Okay. I had a case once where they had a video of where the party posted a video of a 2-year-old in his car seat, and the 2-year-old was going like this. Right. And he was like, isn't this cute? And we're like, why does he not have a seatbelt? Why is he not strapped into his car seat? You know? And the other person thought this was like a great, cute video of how fun they are together. And immediately I was a mom, and my client are like, where's the seatbelt? Like anyway, it was really funny. So why? You're being watched.
Yeah.
That must be the issue of the private investigator. She's having a private investigator follow him around 24/7 to try to get dirt on him with Ever.
But wouldn't that be a violation of a protective order?
I believe it is. I believe when you have a protective order in place, you cannot hire a private investigator to follow someone around. I'm a little bit less big on if there's no protective, if it's just you gathering evidence about someone and there's no restraining order issue.
Yeah.
I think it's a little harder, although it happens here in California, to call that stalking. But the protective orders could not be more clear. If I'm not allowed to follow you around, I can't hire someone to follow you around either, or ask someone to follow you around. You're just not allowed to.
Yeah. Yeah.
Now, the judge has a point. It may be that there's a loophole there, because you can understand kind of if, the other side to that argument, but clearly she's been paying someone a boatload of money to follow him around 24/7. And this is what they found, that he took him on a motorcycle without a helmet on, which is like, how stupid can you be?
Yeah, that certainly is dumb.
Like that's a dumb thing to do no matter what, but you're in a custody dispute. The fuck are you doing?
And you weren't around when Commissioner Manaus said, hey, let's knock that off. Make it any transportation needs to be on 4 wheels. He said 4 wheels.
And this is the other thing that's like that just really, that's just very different than what I'm used to. Typically, things like this, if somebody filed a motion and was like, the other party is taking my child around on a motorcycle everywhere they go, and the other party was like, no, it's safe. Let me show you why. I could see a judge ruling the child may not ride on a motorcycle, or the child may ride, But this notion of like, well, he's taking him on a motorcycle, and the judge be like, all right, no riding on motorcycles. And then them being like, well, he like puts toxic paints in art class. Nope, no toxic paints in art class. Like when a parent has custody of a child, the courts don't like start saying things like, you can't ride around on a motorcycle, and you can't, do parkour because it's too dangerous. And you can't you have to defer to because if you're going to make rules against that, well, what if he takes ever skydiving tomorrow? Like the court has to say to the parents, you know what? I have to rely on your judgment. And if you don't have good enough judgment, then you can't have custody.
Well, it seems like neither of these two have good judgment.
I agree.
And they have horrible co-parenting skills. Like it's just how many times have we been at this? It feels like every time we get to a hearing, we find out that there's, this wasn't coordinated and we've been behind on this. And it's just like, I don't know. I mean,
look, this is the quintessential example of what you hear judges say to families in family court all the time when you have really ugly custody battles, right? You need to love your child more than you hate each other. And they're not there yet. This is more about the other one than it is about their child. It is. It's more about the other one. And I say that also with respect to calling the police, right? I'm not saying that he shouldn't have called the police. Okay. I didn't even hear exactly what happened. But I mean, this is setting up. He's not really being harassed by her, by trying to talk about parent issues through her sister, right? Is it a violation of the order? Yeah, it probably was. But you call the police when someone's threatening your physical safety. You don't call them when somebody's sister says, what time can I pick up the orange juice? And he's absolutely right. It's a violation of the restraining order, and she's dumb for doing it, and she shouldn't do it, blah, 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 blah. But it also doesn't require police officers to come. That's about her. That's not about their child or about their relationship. Now, I don't believe that he's abusing her by calling the police. And the judge said it best, I can't start ordering people that not to call the police, right? Can you imagine a judge saying you're restrained from calling the police? This is, again, it's Laura Owens. When people say why can't we order her not to file any more restraining orders? It's could you imagine a judge telling someone they're not allowed to file any more restraining orders? You can't do that. I can't do that.
In Laura's case, you should be able to because we know she abuses it.
But a judge cannot tell someone you're not allowed to file any more restraining orders. Just like a judge can't tell someone, even if the judge made a finding that Dakota had made false reports to the police 6 times, which clearly it hasn't happened yet, the judge still couldn't order that. Yeah. Because you can't order someone not to call the police. Look, I just don't. They're going to have to get over this. They're still, it's all the cliches, and I ask people this all the time on Hot Bench, right? It just happened last week, right? What is the opposite of love?
Hate.
Exactly. That's what everybody says. It's hate. It's visceral, horrible, angry hatred. No, it's not. Obviously, you know the answer. Right? Or did you actually think it was hate?
No, I thought it was hate. Love. Shit. The opposite of love is hate.
No, the opposite of love is not hate. The opposite of love is indifference. Okay?
Is that the opposite, or is it just an offshoot?
The opposite of loving someone is not giving a flying F about them. When you hate them that intensely, it's because you still love them.
I hate Laura Owens. I don't love her.
Oh, I don't know. You might.
I was I hate her. I don't. There's no.
I get
love
what you're
there.
saying, but I say to people all the time on the show, like, exes who are like, I don't care about her anymore, blah, 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 blah. And I'm like, the opposite of love is not hate. The opposite of love is indifference, right? These people have to get to the point where they're not obsessed with each other anymore. Whether it really is positive obsession, negative obsession, both. They need to get there, and they're not there, because this is still very much about how they feel about each other, not about their child.
And apparently behind the scenes, the reason for apparently that this is, coming from Dakota's side, the crash out is because Dakota has been seen with this Shania girl who he was with when they had one of their times where they were separated, and she used to be
she's jealous.
A good friend of, that's the rumor. I can't prove it to be true, but apparently I think there are pictures of Dakota and Shania hanging out, and Taylor has actually messaged Shania, which she put on her Instagram, saying, look at what Dakota said about you in the past, which is basically, I don't care about her. But that was probably what time where he was courting Taylor again. But apparently now he's back hanging. I don't know if it's numerous times. I don't know if it's one time. I don't know if it was a one-night hookup. I have no idea. But apparently he has been seen with Shania, who Taylor loathes and Taylor doesn't like. And I think he was with Shania with Ever, which is going to send her through the roof, because it's like, this woman that I hate is now spending time with my child. So
of course. And the problem is, if you are of relatively sound mental health and judgment, you can cope with that. And you can do things like not post on social media. And, and if somebody, yes, she may have a right. The court is not going to order her not to post. The court is, the fact that she doesn't mention him by name might make it a little harder to hold her in violation of a restraining order. But the bottom line is, if someone said to me, you just have to not post anything about Laura Owens on social media to get custody of your children, that'd be the easiest thing to do in the whole world. I would do just about anything to not lose custody of my children. And it's not, I think it takes someone who is not of sound judgment and sound mind and body to not be able to control themselves from doing that.
Well, the other easiest thing in the world to do is prove a pregnancy. We know that. And
not commenting on that. But
I think that we're in the same boat when it comes to that. But yet after today's hearing, I'm just like, well, the judge isn't coming down on her for the 11 post at 5 o'clock in the morning this past Saturday. Yeah. She's going to continue to do it. So yes, I agree that it would be so easy to stay away with your custody of your child up in the air. If a judge says, you post about this, I'm taking your kid away, and she still does it. But the judge isn't saying that. He's not laying down the hammer at all.
Part of what it sounded like to me is that the judge seems to think that in order to make something of that, they need to file something to hold her in contempt, or to hold her in violation of the restraining order or something, which I understand that. And that would definitely be the case if you showed up at a hearing about if you were in a divorce and you showed up at a hearing about selling the house and you said, well, he violated the restraining order. And the judge was like, yeah, that's not before me. But if the judge is making these ad hoc custody orders, right? No motorcycles, no more. Why not take into account somebody saying she can't even control herself from filing stuff on social media? Look at her. It would seem to me he could take that into account, because he just seems to have unlimited discretion.
Yeah.
I don't know. I don't understand the procedural, we call it in law, procedural posture. I don't really understand the procedural posture of all these hearings. That's my problem.
And I don't know where it's going. I don't know how long we continue to get these hearings. Like you said, he mentioned about a trial. But
and then he said there was some sort of motion. He said there was some sort of motion to set aside the stipulation, did they say? Or set aside the judgment? I should have written it down. But so there's something
pending. Making a shawl. I get it.
Yeah, I was making a lanyard.
What's a lanyard? What is that thing?
Have you never been to summer camp? Steven.
Not
Steven,
since
okay,
I was,
everybody has to tell you about this. Okay, it's like
I didn't know that was the name of those things, but
it's like string. And you do the this and the this and the this and the this, and then you make it a keychain. I'm making this one for my daughter. It's very calming.
Did you just pick this up, or you're just relearning it? Why are you doing this?
No, I've been doing this for years, but so you want to know why I'm doing it? Okay. Because doing the first stitch is very hard, and I don't know how to do it. So I can't just like do these all year. But when I go to summer camp, when I go to grown-up summer camp,
When
they
did
have
you go to
people
grown-up summer camp.
a week and a half ago, like family vacation.
Oh,
But when I go, somebody else watches my kids, and I do grown-up summer camp. So because they have activities for the adults and the
where
kids.
is this grown-up summer camp?
It's the best thing ever. It's in Lake Arrowhead. It's a camp for UCLA alumni, and you go
to
and
UCLA.
I did it. My husband went to UCLA.
Oh,
But I went as a child with my parents. Okay, so we can still go because my husband went there, and so I take the kids and I let somebody else watch them, and then they have like activities for the adults, like beer pong and like arts and crafts and like
You do
traders
this every summer.
Every summer, same week, every summer with the same people. So it's
Is
like
it-
all the same people that I've known for years.
Is it 4th of July weekend?
It's the week before 4th of July.
Oh, okay.
Yeah. So anyway, so when I go, there's somebody in the arts and crafts studio to start these for me. So I finish them, and then I run out of them, and then I don't do them again for another year.
How many of those do you? How many lanyard keychains?
And by the way, I also win every game of beer pong I play. I'm still very good at beer pong. Except, wait, hold on. This is the ultimate test of whether you're a Southern California guy at heart. What do you believe beer pong should be called? What do you believe the actual name for that game is?
Wasn't it? I was thinking quarters. No, that's
No.
quarters.
Where you throw the ping pong balls into.
Ping pong ball into. I think I've always known it as beer pong.
No, it's called Beirut. That's what it's really supposed to be called.
Heard of that?
But apparently that's a West Coast thing. And so when I went to college on the East Coast and I was like, let's play Beirut, everyone was like, what are you talking about? And I found out that on the East Coast they call it beer pong. So there you go.
We got a question here.
Oh yeah.
Are they not in court in person because of the protective orders, or is it convenience?
No, it's a convenience issue. Yeah, it's easier to appear remotely. There's an exception I'm sure it's in theirs too, for court proceedings in restraining orders. So they could both be there in person if they wanted to. In fact, there was a temporary restraining order in place when they showed up for the last protective order hearing in person, like for the long one in person. So it just doesn't apply. That's not why. It's just a convenience.
Okay, this is something that the people were talking about, and you brought it up when she went to her Starbucks.
Oh, such a bad. You gotta like think.
The way Dakota and Taylor were mirroring how they sat when they put their hands was wild. I didn't realize they were doing it in unison. They're basically saying like whatever Taylor was doing in her seat, Dakota was doing as well.
Oh, I wasn't paying enough attention. I was just noticing that he was very strategically like sort of away from the camera, and that was not an accident. They didn't want him as close up to the camera.
And she was obviously in front of it the whole time, but
and like the problem
at least she
is
didn't put her feet up on her chair this time. Last time she had her feet up on her chair.
Yeah, which is insane. But
sweat.
Also, didn't you notice yes, he was far away and you could comment on that, but every time she rolled her eyes, you could see it. It was right there.
Yeah.
And she looked, and she just and she looked like she was fixing her hair based on her mirror image and stuff. It does not look good to a court. And it doesn't actually, I don't think, mean anything bad. I think it's your natural reaction when you're sitting here to be like, oh, my hair's out of place. But as a third party looking in, it looks ridiculous. So people don't understand that when they appear on Zoom.
Yeah. And you think even her sipping Starbucks is not appropriate?
Yeah. It looks bad. Do I think like a court would be like, ma'am, why are you why are you drinking your Starbucks? Like you should, no, but it doesn't give off an, I take this seriously. I'm here for custody. Like I'm a poor person who needs the help of this judge. It comes off as like very privileged, snobby. And if you just kind of think of what a judge is used to seeing, you do not, some judges don't even allow water bottles in the courtrooms. Okay, some judges say no drinks at all. Most now allow water bottles. But do you think in any serious courtroom, people are there with these large Starbucks drinks with foam all over them, sipping them? Nobody would ever do that in a real courtroom, ever. And you can imagine how weird that would look if someone was sitting in front of a judge in a courtroom with this big old Starbucks thing, sipping it and flipping their hair. And that's what the judges are used to seeing. And so you put them up on Zoom, and they're just not used to seeing people kind of in casual, like, oh, I'm knitting, I'm doing whatever, I'm
lanyarding.
Yeah, they're just not used to it.
That would have been so awesome if Taylor was lanyarding today, along with you.
It would have been awesome.
She's sitting there with a lanyard in her hand. Steve, you seem actually indifferent to LO. I think you hate what she does. No,
I agree.
I don't. I hate her. I do. I also hate what she does, but I hate her as a person. And I don't know her. I've never spoken to her on the phone. I've never met her in person, but I hate her. I do. And I hate what she has done to Clayton, to Mike, to Greg. I find her incredibly annoying. Yeah, I do.
I really feel like I don't have enough energy to hate her.
Because I definitely don't sit here and been like, I don't care what Laura does, because that's indifferent. Like, whatever. She's going to do whatever. That's not how I feel about Laura. I'm very...
I get it.
Laura, I'm not indifferent to her. No.
But it's because it impacts you, what she does.
Well, yeah, that's why I hate her.
Okay, no, but I get it. But that's a little bit different. It's kind of, right? You know what I mean? Like, I don't know.
For Rachel, do you think her hair test will be a big deal if it's positive? Apparently, they are still waiting on results.
It's a good question. I didn't hear that part of the hearing, but it depends on positive for what, right? I mean, I don't clearly, if it's, positive for, heroin, that's going to be a big deal.
Well, yeah.
Right. One of the interesting things, though, is, in California, we all know sort of like what's not on your custody time is not relevant. So, for instance, somebody who drops ecstasy at a party and then has custody of their kids 3 days later, like, courts are not going to want to hear like they did ecstasy 3 days earlier, therefore they can't have custody of their kids. If they didn't have custody of their kids at that time, if they're not addicted to drugs, it's sort of irrelevant. So that's why I think it matters what it tests positive for and what representations she has made about it in the past, right? If she is copped to being on antidepressants or benzos or something like that, and it's positive for that, no big deal. It shouldn't be a big deal. If she's denied taking psychiatric medication and then that medication pops up, then you have a problem. Is she abusing it? Why is she denying it? So I don't know what they're looking for, I guess is the answer.
For your information, they need a judge to review Dakota's side wanting to toss out the August custody agreement, which is 2025. The commissioner can't
rule on that. That makes sense. So I guess my question is why are they planning on having a trial in front of the commissioner? Because isn't he talking about a trial? That's kind of what I'm
talking about for him. That part I didn't understand.
Right. And I get that makes perfect sense. The custody case is not even before the judge. It's the domestic violence restraining order case that's before the judge. And this is all really happening, it seems like, as a offshoot of that, it seems to me. But that's another reason why I kind of don't understand exactly what procedural posture we're in, So maybe I'll figure it out. I don't know. That one guy who was doing all the covering, I guess he's not anymore, right?
Lawyer T. Yeah, he got bullied off of social media.
Which, by the way, that I thought his coverage was lopsided, but that's horrible for anybody to bully someone who has his worst offense is lopsided coverage off social media. That's ridiculous.
Yeah. Yeah, apparently he got doxxed.
That's horrible.
They started attacking him because he's a gay man who's married and has a child, and I guess stuff was getting around about his marriage, his child. Like, yeah, it was.
That's terrible. There's no excuse for that, and I hate that.
Yeah. So now the only other people that are covering it are content creators that clearly have biases, like
you. No.
I haven't been.
You don't have a bias, I don't think.
No, I just
No.
stick to, I mean, the thing that I've been saying about Taylor ever since Saturday, and I've put out a few videos and said it on my podcast, is just I just don't understand why she would go against the order of the judge. Yet here we are today, and it doesn't seem to fucking matter. So I guess she can do what she wants, because certainly she's going to get a slap on the hand. If she didn't even get a slap on the wrist today, it was just, hey guys, knock it off. Don't talk about each other online. Okay.
Yeah.
It seemed like they both violated it. Him indirectly, she and look, maybe she clearly violated it, but he didn't. Like, does his side need to file something that she violated it? Or
so I think that's what the commissioner was saying. But I don't understand why that would be the case, right? Because this was a hearing to revisit parenting time, where the judge apparently just has discretion to adjust the parenting time. So I understand that the judge could not have made a conclusion today. Taylor, Frankie, Paul, you are in violation of this restraining order, and I am imposing, something on you, right? Some penalties would be criminal, but some could be civil, right? I understand why he said, like, I can't do that here, but I don't understand why he felt like in order to raise that issue, it would have to be fully briefed, because it's not like the court would be concluding as a result of an adjudicated violation of an order, I am doing this. It seemed like the judge was just doing what was best for the kid, and he could adjust the parenting time. So I don't know why it would matter. But I thought I very clearly heard him say, you got to brief that. And the same thing with the investigator, right? If you're going to file a motion trying to say she's violated the restraining order, I want briefing in advance on the issue of the It seemed like he wasn't even willing to say, like, all right, I'll take that into account. And I don't know why.
Well, I think what I'm going to do now, since this is run pretty late, is I'm going to use our conversation.
Yeah.
As my weekly podcast tomorrow, because I don't want to sit here and record. I still got to record my daily roundup. I still got to record my sports podcast, and I was going to record a separate one for my weekly interview. But I think I'm just going to take this audio for people that missed it, just because it's got good stuff in it, and I just don't have time to record that.
Are you talking all about Circa in your weekly sports podcast?
I did today.
I'm going to listen then.
Yeah, somebody came to me. And let me know what you think. Yeah. You know what? We'll take this off air. I'll tell this off air.
Okay.
But again, thank you everyone for tuning in. I appreciate it. If you missed it, this conversation with Rachel, which went about an hour once the hearing ended.
Really?
I think it was even talking for an hour. Yeah, because the whole thing is 2 hours and 11 minutes. And that thing, I started at 5 minutes before it came on. They came on at like 3:02. Yeah, it's about an hour. That'll be my episode 503 tomorrow. So again, thank you everybody for listening, tuning in. Appreciate it. And we'll talk soon. See ya.
Bye.